Directors can, and occasionally do, commit criminal offences, and they can be prosecuted and punished. But this topic is about the 7 general duties in the Companies Act. I'll tell you what they are in a minute. And it's a civil matter, so nobody is prosecuted, nobody is fined, and nobody goes to prison. Breach of the duties can lead to a civil action by the company against the director. There are a number of remedies if the action succeeds, but the most common is a payment by the director to the company. An action can be brought against past directors as well as present ones. A good example is the action against 15 former directors of the Equitable Life Company. It was brought in the name of the company by the then current directors, and, as you probably know, it did not succeed. Because the duties are owed to the company, it follows that only the company can bring the action. And it also follows that if the action succeeds, the benefit goes to the company, not just to a section of it. There are 5 ways in which it can be done. By the shareholders, through the medium of a meeting. This is very rare in practice. By the directors. By the liquidator, if the company is in liquidation. By an administrator, if the company is in administration. A derivative claim by one or more shareholders.
What's the most common method?
It's the directors or the liquidator.
I've never heard of a derivative claim. What does it mean exactly?
It means that a single shareholder can bring an action in the name of a company. If it succeeds, the benefit, the money, goes to the company as a whole and not the shareholder. But if it fails, it's pretty likely that the shareholder has to pay all the costs.
My uncle owns 1% of the shares of the company, and we've just quarrelled about my cousin's divorce. Could he bring a derivative claim against me?
Yes, he could, but it's be a silly thing to do, so it's probably not very likely. It's not possible for the company to give a director immunity for the consequences of a breach of duty action against the director. Any attempt to do so, whether it's in the articles or in a service contract with a director, will fail. That's a matter of law. It's possible to insure against the risk. The company can take out and pay for directors' and officers' liability insurance. If you've not got it, it's something you might consider. It comes at a cost, of course, and there will be conditions, but it gives protection for these risks and other risks too, and also the cost of directors' legal expenses.
We haven't got insurance for this, have we, Diana?
No, we've never considered it.
I think it's something we should consider. Could you write a report on it and have it ready for the next but one meeting? And have the papers circulated at least 4 days before the meeting.
Okay.
Let's now look at the duties. There are 7 of them. Duty to act within powers. Duty to promote the success of the company. Duty to exercise independent judgment. Duty to exercise reasonable care, skill and diligence. Duty to avoid conflicts of interest. Duty not to accept benefits from third parties, and duty to declare an interest in a proposed transaction or arrangement. A lot of the actions are on the duty to exercise reasonable care, skill and diligence. I mentioned the Equitable Life case. Here's another one, Dorchester Finance Company versus Stebbings, 1989. The action succeeded in this one. There were 3 directors of the company, and one dominated the other 2. These 2 signed a number of blank cheques, which the dominant director used to commit a fraud. The 2 directors did nothing. They didn't even look at invoices and bank statements afterwards. They were not dishonest, and they'd not gained personally, but they were in breach of the duty of care.
We all sign blank cheques from time to time. Should we stop doing it?
Yeah, we probably should. But at the very least, we need to see how the cheques are being used afterwards.
It's obviously an enormous subject. How would you sum it up in a few phrases, Roger?
Directors should use the knowledge and skill that would reasonably be expected of a director of their type in a company of their type. More is expected of a director of a quoted public company than is expected of a director of a small private company. But there is a minimum standard expected even in a very small private company. If directors do happen to have particular knowledge and skill, they are expected to use it. Directors do not have to be full-time, but they should give a minimum amount of time and effort to the company.
It's all a little intimidating.
Yes, and I'm wondering if I want to be a director after all.
Don't worry, you'll almost certainly be okay. There's more than 2.5 million companies in the United Kingdom, and you don't hear of all that many actions against directors. You'll almost certainly be okay. You should know the risks, though. Let's move on to the duty to avoid conflicts of interest. Directors must avoid a situation where they have, or could have, a direct or indirect interest that conflicts with the interests of the company. The Companies Act does not give examples, but it could include becoming a director of a 50-50 joint venture company. More obviously, it could include becoming a director of a competitor or a shareholder in a customer.
Marks & Spencer's PLC is one of our customers, and I own 1,000 shares in it. Am I in breach of duty?
No, you are not. The Companies Act says the duty is not infringed if the situation cannot reasonably be regarded as likely to give rise to a conflict of interest. This means that it's okay if the conflict is trivial, and with great respect to your shareholding, conflicts don't come much more trivial than that. It would be a different matter if you had a major shareholding in one of the customers. In all cases, a conflict of interest may be authorised by the shareholders. It should be done in advance, and it needs an ordinary resolution unless the articles call for some higher majority. The shareholders own the company, so they can give permission for anything. There must be total disclosure of all relevant facts, and the director, if he or she is also a shareholder, cannot count towards a quorum or vote at the meeting.
I've heard that the directors can authorise a conflict of interest. Is that right?
It is if the articles allow it. I'm sorry it's complicated, but this is the position. For a public company, directors can only authorise if the articles or a shareholders' resolution allows it. For a private company registered before 1st of October 2008, directors can only authorise if the articles or a shareholders' resolution allows it. For a private company registered from 1st of October 2008, directors can authorise unless the articles or a shareholders' resolution says that they cannot. Once again, authorisation should be in advance, and there must be total disclosure of all relevant facts. And the director concerned cannot count towards a quorum or vote. The same goes for any other director with an interest. Of course, just because the directors can authorise a conflict of interest, it does not follow that they should. One of the other directors' duties is to promote the success of the company, and that means putting the company first.